Which mic are you, 11?
Let us pray. Dear Heavenly Father, we thank you for waking us up this morning and bringing us to this the Capitol to do your will. We ask for wisdom, we ask for deference, discernment, and we ask that you continue to let us do your will. In Jesus' name I pray, amen.
Thank you for that. Well, Senator Hatchett, you are first on the list with Senate Bill 28. Tell you what, if you'll walk down here to the podium. And we are working off LC 338495 EC. Is that what you have?
Yes, Mr. Chairman.
Is this your first time presenting a bill in the Senate?
Yes, it is, Mr. Chairman.
Okay. You can go ahead.
Well, first off, I want to say it's an honor to be here in front of this committee, especially considering this is my first time presenting. And I'll say it's a greater honor that the chairman was the second signature on this bill. And I hope that brings me some good favor today. As the governor's floor leader, it's also an honor to bring this bill. This is a governor's bill, and the goal of this bill is to amend Chapter 11 of Title 15 of the Official Code of Georgia relating to the Juvenile Code and domestic relations. And it's to strengthen, clarify, and update provisions relating to the protection of children, to require annual training for juvenile court intake officers, to provide for the consideration of evidence, including hearsay evidence, in certain juvenile proceedings, to revise provisions relative to the juvenile code and the reporting of child abuse, and to provide for related matters, to repeal conflicting laws, and for other purposes. The provisions in this bill originate from requests received from juvenile court judges, Georgia CASA, and child advocacy organizations to refine and strengthen provisions of the Juvenile Code after its comprehensive revision in 2013. In general, the provisions of Senate Bill 28 create procedural efficiencies, expand tools available to juvenile courts to prevent unnecessary reliance on foster care, and ensure that the system operates consistently and with integrity. Now, this is a 16-page bill. The provisions amend 5 different sections, and I'm happy to go through line by line the changes in the bill, or I can take specific questions. I'm also honored to have the representative from DFACS, Tom Rawlings, here, who is also available to answer these questions. He's the expert in the subject matter here, and I would like to be able to defer to him with some of the questions that I may not be able to answer personally.
All right, let's start with questions from the committee. I have one question on the hearsay provisions. Walk us through the places in the bill where we are allowing hearsay to come in proceedings and what type of proceedings those are. And I think you do have some expertise. You mentioned before to me, I believe your wife may at least practice in this area.
She does.
And so you gave me, when I asked that question initially with the bill, you started giving me some feedback on that. And if you could just share that with us, with the committee.
Yeah, the way that the current code is written now, it actually allows for hearsay provision. This just clarifies it to allow for hearsay evidence to come in hearings that are not adjudicatory hearings, which would be in the juvenile court. Those hearings are technically considered trials, where you're going to take the rights of a parent away, and so those hearsay exceptions would not be allowed in those. But in the initial hearings, the PPHs, hearsay evidence is allowed only, but it's only admitted if the judge finds it to be reliable. So it's not just a blanket, we're going to let all hearsay evidence in. The judge is still there as the gatekeeper for that evidence.
So in the juvenile court world, you're talking about more of like a preliminary hearing and a review hearing, but not a hearing where someone's rights can be terminated when they have a right to have a trial, in essence. Is that what you're saying?
Correct.
Okay. Senator Calzert.
Thank you, Mr. Chairman. That was the same thing that had my attention, because I don't know the juvenile code, what 1511-146 even references, that Here on lines 106 to 108, you're allowing this hearsay. And I was wanting to make certain, I mean, of all the rights of a person, you know, to take their child away from them, I would certainly hate to think that could be based on hearsay. And since there's no juries involved here in the probate court, I mean, it's kind of interesting. The judge, the one you're saying is going to make the decision whether or not to pay any attention to the hearsay, is the one that's making the ultimate ruling after having heard the hearsay. You know, it's nerve-wracking. Do you know what 1511-146 references? Those determinations or findings determined by that code section?
I do, and I actually have the code book here that I can give to you.
It's
It's
a
the
lawyer
preliminary
after my own
protective
heart. What's that reference?
I can read it, but it's preliminary protective hearings and findings. At a preliminary protective hearing, the court shall determine whether there is probable cause to believe a child is a dependent child and whether protective custody of a child is necessary to prevent abuse or neglect pending the hearing on the dependency petition. And my understanding is it's also known as a 72-hour hearing. Once a child is taken out of the custody for a number of reasons, if there's a belief that the child is in danger, at this very first hearing is when the hearsay evidence would be allowed. And then typically it's 2 weeks following that PPH, and correct me if I'm wrong, Mr. Rawlings, 2 weeks later is when you would have an adjudicatory hearing, which is the trial where hearsay evidence would not. So the hearsay evidence really is allowed in an attempt to make sure the child is protected. And it's not a permanency hearing, and it's not stripping the rights of a parent, the rights to have that child in their custody away permanently in any way.
But for up to 2 weeks, then they would be taken away and put in protected custody.
In 2 weeks they have the hearing, and at the conclusion of the preliminary protective hearing, it's actually codified in 1511-145 that the parent is read all their due rights or due process rights, which includes the right to an attorney, and if they can't afford one, to an appointed attorney, the right to call witnesses, the right to cross-examine all witnesses, the right to present evidence, and the right to a trial by the court. And so all this is presented at the PPH, and then typically 2 weeks later is when the final hearing would be.
But hearsay, by its very nature, denies them the right to cross-examine that witness because they're not in court to be confronted.
At the PPH, they are allowed to cross-examine a witness that may be bringing forth hearsay evidence, like a caseworker or something like that, and they can actually discredit that witness, but the evidence that they're bringing forth is allowed if the judge considers it reliable. And then at the actual trial 2 weeks later, they would be able to confront them because hearsay evidence is not allowed.
Okay, thank you.
Do you want to call a lifeline to address that directly behind you?
Yes, I would. I gave it my best shot, I promise. Yes, you may. And the page is marked.
Thank you. Afternoon, Mr. Chair, members of the committee. I want to first say that I'm wearing Pete Scandalakis' jacket because I left mine in my truck. And so I hope that will clothe me with extra authority today.
At least you look good.
So on the issue of hearsay, general procedure, as we know in juvenile court, is that prior to removing a child, the DFACS generally calls the court, gets a preliminary order determining whether or not there are reasonable grounds to believe that the child is at imminent risk of harm. We then have the preliminary hearing within 72 hours, usually within 48 if possible. And then, of course, as we know, we decide at the preliminary hearing whether or not there are reasonable grounds to go forward, including, at that time, of course, everybody's appointed an attorney. Sometimes at that hearing we are able to resolve some things. But I think in terms of this bill itself, what we're really talking about in terms of the hearsay is not a substantive change to the code. So I was on the bench, juvenile court, from 2000 to 2007. There is a stark difference between what is admissible adjudicatory evidence to determine by clear and convincing evidence whether or not a parent is unfit to raise a child at that point because of some disability or some incapacity of the parent. The time that we have traditionally, especially under the old code, used hearsay was to kind of elucidate this child's circumstances. So, for example, you've already determined that the parent has, by clear and convincing probative evidence, code evidence, that the child does not need to be or at least that the parent is not capable of caring for the child at that point. But there are other things you need to determine, such as what's going on with the child's school, what are the child's favorite things to do, what, for example, is the child getting any kind of medical treatment? What sort of setting would be best for the child? Is there a relative out there who might be willing to take the child that we need to look for? These sorts of things are really kind of wrap the child's, which we help the court to determine sort of the wrappings of the child's environment and determine whether or not even the child needs to be in foster care or perhaps can go back home. So what we've had in the last few years, and this is why this particular provision is especially coming from CASA. Many of you know our wonderful court-appointed special advocates organization. They are in almost every circuit in the state now. I think they maybe have one left they're not in yet. And these CASA volunteers go out and gather a great deal of evidence as guardians ad litem for the child. They then come to the court, and some of what they know, we need to make sure it's evidentiary, but a lot of what they know just kind of, as I said, helps explain the child's situation better. And we've had in the past few years, just due to some clarity or lack of clarity in the 2013 or was it 2014 revision of the code, we've had some questions about whether or not CASA reports and similar hearsay. In hearsay, we're not talking about just word off the street. We're talking about things that the court also deems at least reliable and trustworthy that can be proven. To whether or not that can come in, not in the adjudicatory part, not in the part of the case that affects in which we determine whether or not the parent is fit or unfit, but rather in determining how to deal with the child's, what to do with the child in terms of disposing of the case, reviewing the case, reviewing the child's progress in the case. And as you can imagine, in juvenile court we have, of course, we have the preliminary hearing, we have what we call the 10-day hearing. It really should be within 10 days, less than 2 weeks whenever possible. And then we have regular review hearings throughout the life of the case. And as you can imagine, the best way to learn about the child's current circumstances, the parent's compliance, what's going on with the parent in terms of their doing what they need to do to get their child back. We don't want to have to bring in everybody, every teacher, every therapist, everybody who knows everything about the case. So we have traditionally, and for many, many years, allowed hearsay in those sections of the proceedings. But Chairman Counselor, especially, we would certainly never, I would not promote any kind of law that would allow us to have hearsay when we're actually determining the parent's rights. And I think the Court of Appeals has made that very clear to us. Supreme Court has made that very clear to us. There was a time a number of years ago when I was still on the bench when the Court of Appeals reversed a bunch of juvenile court hearing cases because some of the courts were just kind of having hearsay, willy-nilly. But I think over the last few years we've really cracked down on that. The judges are doing a much better job of making sure that they're separating the wheat from the chaff and allowing only probative evidence for the substantive part, and then hearsay just for as I said, to sort of flesh out the child's situation.
Thank you, Mr. Chairman. So from where I sit, though, taking away a child for 2 weeks is still depriving parental rights. Just because it's for a finite period of time doesn't mean you're taking my child out of my home in a protective custody for 2 weeks based upon out-of-court statements where I can't cross-examine. Well,
my understanding, in my experience, what we're doing at the preliminary hearing is we're actually, in all of my experience, we're actually not just doing hearsay. It's not people, saying I heard such and such. It's evidence. It just may not be as gathered together as the evidence that you have at the adjudicatory hearing or the 10-day hearing. You still got to show that there are a strong rational evidentiary basis for keeping that child out of the home during that period of time. So it's not a situation in which you're using hearsay willy-nilly. Really, the hearsay amendments here, the hearsay clarifications really do apply to the dispositional and the review parts of the case, and not necessarily to 1511-145, is my understanding.
Okay. Can I ask one separate subject matter? All right, Section 11 of your bill deals with the mandatory reporting requirements.
Sure.
And that's come up with us with sexual predator bills, et cetera, whether that gives you any kind of safe harbor, et cetera. And the way I understand it is that if you in good faith report some type of sexual abuse, or in this case abandonment, neglect, or whatever, that you are immune from suit by the person that you accuse of being the abuser, right? Or the neglector,
Right,
whatever
there's
it might be.
Immunity
Not
for that.
the victim, not from the victim.
Right.
You have added a whole new definition of child abuse here on line 271, where it used to be endangering a child, was
Right.
child abuse. Now it is emotional abuse of a child.
Right.
And that's defined on the next page, lines 291 through 295. This really gives me the willies a little bit when you have a statutory duty now to report emotional abuse of a child, but how in the heck can you, that's such a subjective standard. If you see a parent yelling at a child in public or humiliating them or, cussing them out because they struck out in a baseball game, and then you're violating this statute for mandatory reporting. I'm nervous about that. I'm trying to figure out exactly why we're changing that all of a sudden from endangering a child to emotionally abusing them.
It's not intended to be a substantive change so much as it is to clarify and change. So if you look in the current code in 1511-2 as to the definitions, and let me see if I can pull up. Oh yeah, go ahead. Here comes Senator Hatchett.
So that actually gave me pause as well, Senator Cowsert. But endangering a child actually isn't codified anywhere in the Code of Georgia. And the code section was endangering a child was actually replaced with F on page number 12, which is an act or failure to act that presents an imminent risk of serious harm to the child's physical, mental, or emotional health. So while it appears that it was replaced with emotional abuse of a child, that definition was actually replaced with F on the following page.
So the emotional abuse is just an add-on under
Yes.
this case then? Okay.
Yeah.
And if I might add, Senator, what we did is, if you look at 1511-230, that defines emotional abuse. It's currently in the code. And so what we're trying to do is align the definitions in 1975 with those in 1511-2. And I would just simply add that, remember that, it's what we're trying to encourage in the mandated reporter statute is that when individuals have a good faith, whether they're professional or not, when they have a good faith basis for believing that a child is in danger, we want them to feel free to report. We can sort it out later.
But no, not just feel free, you're mandating.
If you are a
that they do
mandated
that.
reporter, you are. But remember, it is a good faith basis to report. And I think, that by clarifying the definitions and making sure that the definitions in 1975 match up with those that are actually defined as abuse or neglect in 1511-2, we do help clarify that.
Thank you. Appreciate it, Mr. Chairman.
Any other questions from members of the committee? Anybody else want to be heard on the bill? Nobody signed up to speak on it. Senator Hatch, if you want to come back to your seat, you may be needed for your vote. We didn't get to haze you. There's not really a lot of time for that. You kind of haze yourself a little bit with this one, though.
Well, I appreciate it.
Yeah. At this time, we will take a motion, if you want to make a motion on this bill. We have a motion to pass by Senator Jones. We have a second by Senator Rhett. Any discussion? All those in favor of the motion, if you will raise your hand. Any opposed? You passed unanimously. Congratulations. Thank you, Director Rawlings. Thank you. All right, we'll move on to Senate Bill 75. Senator Jackson. We are working, let me make sure I get my stuff together. We're working off LC 412958S. Is that what everybody has?
That's correct.
Is that what you have? Okay. Go ahead and tell us about your bill.
Thank you, Mr. Chairman. I stand here really to offer a bill that I'm proposing is kind of a cleanup bill. About in 2018, you all passed, this body passed a bill that would allow those who were victims of domestic violence, who had a temporary protective order, to be able to bring that order to their leasing company or the person who holds their lease. And with 30 days notice, they could get out of that lease. You all passed that bill out of this committee and it was signed into law. So I'm simply following up to add stalking. So if you have a temporary protective order or a criminal order from a judge that says that you have been a victim of stalking, that you can take that to your tenant. You're the tenant, so you can take that to your leasee, present it with 30 days notice, and be released from your lease without penalty. So it's written to be very similar to what we've already done in the code, just to be parallel. Stalking was already in the code. We didn't make up that definition. So I hope that you all will consider this favorably. And I do have some experts here who are prepared to speak to this in more depth.
All right, thank you, Senator. And so to be clear, you have two different types of TPOs under Georgia law. You have the family violence TPO and the stalking TPO. And the law we had, was it 2 years ago? Was it? We had 3 years ago?
It's 2018.
2018. Just applied to family violence TPOs, and what you're doing is mirroring that and putting it into the criminal and the civil stalking TPOs and convictions. That should be clear.
That's
criminal stalking conviction or a stalking TPO as well. Is that right?
That's correct.
Okay. Anybody have any questions for the author? Okay, we have a couple people signed up to speak on the bill. Is it Miss Lemeska? Am I saying that correctly? Miss Nikki?
Close enough.
Close enough.
I will answer to anything with a name like that. Chairman Strickland and members of the committee, thank you for your time this afternoon. My name is Nikki Lemeshka, and I am the program manager for the Georgia Commission on Family Violence, and I'm happy to appear to relay the commission's support on this particular piece of legislation. I worked in the field of family violence for 20 years in settings ranging from one-on-one advocacy for victims seeking temporary protective orders to navigating the state's coordinated community response. Since 2016, I have spent a lot of my work cultivating expertise in the area of stalking. It's in that capacity that I appear today, as this piece of legislation addresses a significant gap in protections for victims of stalking statewide. As a commission, we have made significant strides in the last few years to educate stakeholders, including advocates, law enforcement, prosecution, and others, about the problem of stalking. We have focused on the fact that stalking is a prevalent problem in Georgia, often hidden in plain sight. In fact, 4% of women and 2% of men are stalked each year in the United States. And when you boil those numbers down to what that looks like for Georgia, that means that roughly 312,000 Georgians are stalked each year. For those of you that are more visual, that's about 15 Phillips Arenas or State Farm Arena in 1 year. Full of stalking victims. Stalkers today employ a variety of mechanisms to instill fear in their victims. Things like surveillance tactics, life invasion, intimidation, and interference through sabotage and attack are among those tactics. Almost half of stalking victims experience at least one unwanted contact per week, and the majority of victims are stalked by someone they know. This takes a toll on victims, as I'm sure you can imagine. In studies, roughly half of stalking victims fear what will happen next, and a third fear that the stalking will never stop. These victims have good reason to be afraid. Stalking behaviors are widely recognized to be an indicator of increased risk for lethal violence. As the former coordinator of the Georgia Domestic Violence Fatality Review Project, I can tell you that when we started to take a closer look at stalking in 2016, 2017, we found that 58% of Georgia cases reviewed by the Fatality Review Project since 2004 involved stalking behaviors. That moved us to release a report in 2017 focused on the issue of intimate partner stalking. And among the potentially life-saving recommendations included in that report was tenant protections, which allow a victim to vacate a lease without penalty if they need to relocate for safety reasons. In 2018, as Senator Jackson mentioned, Georgia passed legislation to that effect for family violence, and feedback from both victims and advocates in the wake of that change has been excellent. This particular piece of legislation seeks to establish similar provisions to those previously enacted, but this time for victims of stalking. It's important to point out, as it pertains to lease relief, that these victim safety issues should also be identified as community safety issues. A specific victim may be the target of the abuse, but many others in the community are often victimized by proxy. Sadly, it's not uncommon for patterns of stalking to continue for many years. These behaviors cause 1 in 7 stalking victims to move as a result of their victimization. I'd imagine that number would be significantly higher if it were up to victims, but for them, seeking protection from abuse can be financially draining, limiting their ability to relocate to safer housing. If victims are engaged with the civil or criminal court systems, for example, they're often required to miss work to address issues created by their stalker. And to add to that, the cost of relocation and barriers to safety really start to stack up. Enabling tenants experiencing stalking to move out quickly and without penalty will not only create a better path to safe housing, but will reduce the likelihood of potentially lethal violence in communities throughout Georgia. Thank you for your time.
Thank you very much. Anybody have any questions for the witness? Senator Kirkpatrick?
Yeah, sorry, I'm not a lawyer, so this is a non-lawyer question. What happens if the person who's doing the stalking is also on the lease?
Good question. Well, if the person seeking the stalking is on the lease, this bill requires that the person obtain a protective order or a criminal order in effect as verification that the stalking has occurred. And so in those protective order issues, or in the protective order process, whoever maintains the residence would typically be among the slate of issues that are addressed within judicial discretion. So it should already have been addressed at the time that this particular lease release would take place.
It seems to me under the current law, and it's still in the bill, lines 43 and 44, you have to have an order that was issued that protects such tenant. We see that in 43 and 44, so I think it creates an argument that would only apply to the tenant that's being protected. So if you had a joint contract, it should not terminate the entire contract based on that reading. Yeah, sure.
So, Senator Kirkpatrick, actually, thank you for your question because it raises an important gap in the law. Right now, until you hear my next bill, you cannot receive a temporary protective order against someone, protecting you from someone who lives in your same residence. Our laws currently do not allow that. So, in your situation that you propose, a person actually would be stuck because they couldn't get a temporary protective order. So we have to adjust that in order to accommodate your situation. And then that would be worked out in the courts, and the judge would make a determination about who could stay in the home and who would leave.
But that would be just under stalking, right?
Under stalking,
Okay.
That's correct. Yeah. If there had been abuse or there had been physical violence, then they would be protected under the Family Violence Act.
Do you have any more questions on that? Senator Calvert?
Thank you, Mr. Chairman. Senator Jackson, you may can answer my question better. This is going to sound elementary, but I don't handle, violent criminal cases. I'm assuming stalking has some violence. What is the definition of stalking?
Yeah, we have it outlawed in the code. I don't have the.
Looks like 16.5.7, just,
Yeah.
Reading off of line 35, but I don't have that.
Sure, I don't
handy.
have that code with me, but it talks about people who are being stalked, being harassed with phone calls, text messages, emails, as well as being followed and where they're going and traveling. So what we kind of think of traditional stalking as in they're actually following you where you are. All of those provisions are included, but harassment via electronics is included as well in that.
Does that require any type of threats of violence? I mean, I can see couples breaking up and the boy or the girl's, wanting to continue pestering them with Facebook messages or phone saying, please call me, why don't you love me anymore, whatever.
Mm-hmm.
That's a little different than saying, I'm going to kill you or I'm
Right.
after you or whatever. I'm just curious.
No, the current code does not require threats of violence, but it does require demonstrating that harassment is happening. And so that girlfriend who keeps calling and calling and calling and calling, at some point that does constitute harassment. Or intimidate, and it can be intimidation.
Thank you.
Senator Rhett?
To add on to that, if you get a court order that have been investigated, so that would determine whether it's just a boyfriend or girlfriend following each other or if it's real harassment, right?
That's correct. And that's one of I think the beauties of this bill is that we wanted to make sure that the people who own these properties do not have to be the adjudicators of whether or not someone is actually being stalked or not. That has to go through a judge, and the judge will be the judge of whether or not you need protective custody, a protective order against you. So yes, there is a formal judge process that has to go through before you can get released from your lease.
Senator Kennedy?
Thank you, Mr. Chairman. Senator, thanks for bringing the bill. Just a couple of questions following up on Senator Calsert's question. And within the definition of stalking, so it sounds, and I'm learning that too for the first time. So it sounds like the way stalking is defined and the way it would be applied here in this bill, that there's not a physical proximity element to stalking. In other words, I think following up on Senator Calsert's thoughts, you could have someone on the West Coast that is stalking a Georgia tenant without any physical proximity of what most of us probably think of as stalking. It could be all electronic. It could be social media, in which the physical location seems somewhat decoupled from the need to address the problem. Can you help me with that?
Absolutely.
And why it would be fair under those type circumstances, and why it would be fair to everyone involved, because we've got a landlord involved.
Sure.
We've got a victim or potential victim that we need to look out for. But we need to make sure what we're doing, that the size hammer we're using is in the direction of what needs to be addressed.
No, I appreciate that question, and the apartment association had that same question for me. Unfortunately, what we know about stalking is that stalking that begins as electronic only, so begins as only text messages or social media, when left untended, will often evolve into in-person stalking. And so the law doesn't distinguish between cyber stalking and physical stalking. It's all considered one, because ultimately they often lead to the same thing. So, if someone has been stalking you, via social media, the end of that story often is that they will come and find you in person. That people don't stop at just the electronic stalking. That's why they're not separated out.
Would it be helpful if you saw the definition of stalking, if we shared that? Beth with Senate Research, I think, has that pulled up.
I think it would, Mr. Chairman. I think it would, because I follow the senator's logic in what you're saying, but it also strikes me that we've got and I don't doubt what you're saying, that let's call it minor forms of stalking can escalate into more. I think the question is, the difficulty I'm having making is the connectivity to the physical location, and at what point we pass the tipping point where that's the need that needs to be addressed for the person that's the victim?
Sure. I mean, ultimately, people will make that decision themselves based on what feels safe. But we do know that 1 in 7 stalking victims conclude that they would feel safer if they moved away from their residence. And so, what we're trying to do is create a pathway for that 1 in 7 person to be able to move without penalty. So, you know, the thing, we've got the stalking definitions here. So there has to be a pattern in the activity. So it has to happen more than once. Intimidating and harassing in nature, obviously without the victim's consent, and it places the victim in reasonable fear. So those are kind of the stalking requirements, which obviously don't have to be in person, but we know we have just enough stories and enough statistics to know that not in-person stalking will often lead to in-person stalking. So we want to give people the opportunity to move when it becomes necessary for them.
If I could also add something that may assist in connecting the importance of, even if the perpetrator or the stalker is not local, it is an extremely common tactic of stalkers to utilize third-party stalkers to stalk on behalf of themselves to stalk the victim. So what we have found in many of the cases that we have reviewed is that a stalker, even if they're local but at a distance, say they're in South Georgia and the victim lives in North Georgia, or if they live out of state, that it would not be uncommon for them to convince a friend, family member, acquaintance, stranger, to actually gather and obtain information about the victim here locally, including where they reside, or to harass them by proxy. So they're the person then carrying out the bidding for the person from a distance. So it certainly, whether it is by decision of the stalker or the stalker doing it firsthand or by their decision and somebody else is doing it, still does jeopardize the victim's safety, even if the stalker is not local.
Mr. Chairman, a follow-up, please. So is there within the bill, is there a connectivity between the issuance, the request, and the issuance of the stalking order and the place where the victim lives there, so that you've got sort of a one-time protection? Or could a tenant use that stalking order in series to move from place to place, or breach lease from lease based on a stalking order? And is there a time element connectivity there? In other words, how long after the issuance of the order can the victim rely upon it 2 years later and on the fourth apartment that he or she may be in? And if not, maybe we need to tighten that up some?
Right. So there is not a provision that has a time limit on it. This parallels the bill that you all passed in 2018. So there's no time limits on that as well. And so it looks exactly the same. If we want to tighten it up, but we probably have to tighten it up for both of those issues in terms of domestic violence and now for stalking. But right now, you are correct, sir, that in theory, a person could take their TPO, get out of one lease, take the TPO, get out of another lease. In theory, that could be possible.
But are you done with your,
Pardon?
do you have any more questions?
No, Mr. Chairman, thank you.
You would have to have, though, a TPO has to be issued, and if it's ex parte, it has to have a police report going along with it as well.
That's right.
And or otherwise, you'd have to have a criminal conviction or a pretrial release order, or bond basis, stay away bond. So I think that's what we did with the family violence bill. That, to me, is kind of the protection we have built in, is you are going to require that kind of court action or criminal action on a case. Senator Calzert.
Thank you, Mr. Chairman. Senator, welcome to Judiciary Committee. This is just what lawyers do. But, you know, we're trying to think the logical, where this might lead and the precedents that we set. Now, I'm sitting here, we just got this stalking statute, and there is also aggravated stalking.
That's right.
Which sounds more serious as far as threatening. Is aggravated stalking already covered under our current law?
It's not currently covered. So this bill that we offer does cover aggravated stalking. One of the ways that you can get an aggravated stalking conviction is by violating your temporary protective order. So they're related in that way. But the way that we've written this bill, aggravated stalking is covered under this provision.
But yours also covers misdemeanor stalking also.
That's correct.
Because I'm reading the definition of aggravating stalking, 16.591, which I think answers Senator Kennedy's concerns. It says, I'm at the end of subsection A, the behavior in the subsection follows, places under surveillance, or contacts another person at or about a place or places without the consent of the other person for the purpose of harassing or intimidating. That seems to connect more
With
at the
physical place.
location, because what I'm thinking out loud, I mean, obviously we want to protect victims of domestic violence or even attempts at it. Nip it in the bud, as Barney Fife would say.
That's right.
Why wouldn't the same principle apply to somebody? I mean, Atlanta's now the crime capital of the world. What if somebody feels like they might be robbed, or they might be burglarized, or they might be assaulted in their home? Let them out of their lease too, because they're not getting adequate protection. I mean, your landlords are all of a sudden going to, their lease is going to have no meaning, because most people in Atlanta now feel threatened in some way and not protected.
Thank you. That's exactly why we're very clear that you have to have a judge's order, a judicial order, granting you a temporary protective order. Because I think you're right. If we leave it wide open, then any number of people could say they feel unsafe and try to exit their leases. But in this way, we have a stop guard in that we have a judge who has some requirements that have to be met, including, there's a standard of proof that you have to meet in order to get that temporary protective order. So that's our safeguard in for that exact situation that you've named.
Yeah, but I'm not wanting a safeguard, because you're denying the safeguard to victims of other types of crime that might be just as deadly, just as not for a sexual harassment purpose. Those people are stuck in their leases.
The senator knows of what he speaks.
You're a quick learner too. You're doing well, yeah.
In the future, when you're a freshman, let's bring something a little bit easier for your first bill, right? Senator Jones?
Yeah. Thank you, Mr. Chair. I was just going to ask along the lines that Senator Cowser was talking. But when you start talking about issues of stalking, and especially with domestic violence, in your experience, isn't that a little bit different as far as what the potential long-term consequences are? Then yes, I understand a person could be afraid of being robbed, but the issues that are involved with stalking and things of that nature, is it not different than a person just having a general feeling of being robbed or something of that nature?
Yes, sir. I think those are very different.
Senator Kennedy?
Thank you, Mr. Chairman. Just one more follow-up, Senator.
Sure.
I was wondering, lines 60 through 62, those are stricken. Can you tell me why those are taken out or being proposed to be removed from the code section?
The timeline is not the same. July 20th, 2018 does no longer applies to us. So that's why we've stricken it. Would you have liked us to replace it with an updated date?
Well, I was wondering why it was being stricken. I could understand if you adjusted the date, as you're saying, for the timeline so it's appropriate for where we are, but instead of adjusting the date, that provision is stricken, and that's why I was wondering if there was why that was being done or what policy
I think
reason
it's
was
considered
being done.
redundant because the law wouldn't go into effect until July 1st of 2021.
Do you want me to answer?
Yeah, Brian.
I think the reason that was put in
Sure.
there is constitutionally, we can't interfere with any current contracts. And so now, since we're amending this code section, the whole act will not apply to any leases except those that entered into after July 1st of this year. And so we had to restate that in order to make the bill constitutional as far as interfering with existing contracts. That's
Okay.
what Legislative Council. Julius, do you have anything you want to add on that? On page 4.
Right, that when the bill was originally passed,
I see.
line
Okay.
60 through 62 was in there to deal with the contracts in 2018. But now that
Got it.
this code section is already in place, that's not necessary anymore. And so those lines have been. In the line 64 to 67, where we deal with body deterrence, contracts that are executed after the date of the effective date of the bill.
Thank you, Mr. Chairman. I didn't realize it effectively has been put in section 2, the same language. So thank you, Senator.
Yes,
and
sir.
thank you, Mr. Chairman.
Any other questions for the author of the bill? We do also have, is it Ms. Peed that wanted to be heard on the bill as well?
Good evening,
Good evening.
Committee and Mr. Chairman. Thank you so much for allowing me to be here. My name is Marina Peed. I'm the Executive Director of Mosaic, Georgia. We're the Sexual Assault Center and Children's Advocacy Center serving Gwinnett County. I've been involved with them as a volunteer back when it was Gwinnett Rape Crisis in 1992, and we carried pagers. So we've come a long way, and our services have grown as well. Our name, Mosaic, Georgia, reflects the way we help people put the pieces of their lives together after experiencing some sort of sexual abuse, assault, or sexual exploitation. I'm here today to talk about some of the experiences we've seen with our clients, and I don't want to repeat any of the former testimony, but we have seen the impact that stalking has. Sometimes it serves as a warm-up crime that leads to more aggressive physical violence or sexual violence, property damage. But in other cases, stalking will occur after domestic violence or after a sexual assault. And the stalker does this, I guess, to try to get some compliance and get some control over the person that they harmed, often also to prevent reporting. It's a misunderstood and oftentimes disbelieved crime because the actions that they take are generally socially acceptable to normal people, whether it's sending flowers to someone or an anonymous love note, something that friends might think is no big deal, but it could be threatening to people. But that tends to escalate as well. So it goes from being creepy to frightening, and sometimes it can actually end up being deadly. Unfortunately, in Georgia, we have very limited protections. As I mentioned, we work a lot with sexual assault. We do not offer protection for victims of sexual violence to get protective orders. So people that don't qualify for protection under the family violence statute rely on the stalking protection in the code when their perpetrator continues to stalk or harass them after a sexual assault occurs. And who are the stalkers? They're neighbors, former dating relationships, friends, coworkers, students, acquaintances, and they may even be good-looking and charming. But stalking causes a lot of harms, not just to the individual that's receiving it, but also their family. It can affect their work environment, their schooling. We see stalking on college campuses as well. And when a victim is trying to shift her or his activities in ways to try to avoid the stalking, it gets to be pretty mentally stressful as well. But also stalking creates problems for landlords. And I think landlords take interest in this, and I'm going to share an example of working with a victim because it affects their community safety. When a stalker hangs out in a neighborhood, whether they live there or they're friends there, they may badmouth the victim. They may engage neighbors to participate. Let me know if she has somebody over. Drop this off for me. Engage people in ways they don't even realize what they're doing. 2/3 of stalkers commit property damage, and that damage undermines community safety as well. If the stalker is also a tenant of the landlord, they could evict for lease violations, but that eviction process is far more cumbersome and it takes time and it takes a lot of money. We found that many landlords across the state don't understand the gravity of the risks imposed by stalking, or they're absentee, or they don't have the professional property management knowledge. Those will typically abide by the law and no more. We have legal services, 2 victim legal services attorneys and legal advocates at Mosaic, and we've assisted many victims of stalking or sexual assault in negotiating lease terminations or transfers to other properties. I'll give you one example about a client named Amy. It's not her real name. Her boyfriend was Gary, not his real name. But Amy broke up with Gary, but he said the relationship was not over. He sexually assaulted her after the breakup and then sent numerous calls from spoof numbers. He sent text messages, left angry voicemails, demanding to know why she was ignoring him. He showed up at her place of work. She wanted to move, but it was in the middle of her 1-year lease. She called Mosaic, Georgia for advice. Amy stated, "He threatened that if I went to the police after the rape, he would have someone come to my house, and I believe him. He has a friend that lives right down the street, and he's very violent, and he has a violent past." Our team assisted Amy in negotiating with her landlord, and the landlord agreed to transfer her lease to a residential property in a different location without a penalty or a fee. Unfortunately, every landlord isn't open and receptive like that, and having this in the law would help to make that happen. So to summarize, allowing a residential tenant under the conditions set forth in Senate Bill 75 to terminate a lease without penalty will allow the resident victim to pursue safe housing without derogatory rental history. It reduces compounding harms that the stalker is imposing on the victim, and it reduces the risk of property damage or criminal activity on the premises, increasing the safety of all residents in the community, which also helps to protect the landlord's assets. We encourage you to continue to offer greater protection for victims of stalking for their physical safety and relief from the mental anguish that this bill affords. I thank Senator Jackson and all of the co-sponsors of Senate Bill 75 and the committee for your attention. Thank you.
Any questions for Ms. Peed? All right, thank you very much.
Thank you.
Last person on the list is Hayden Stanley with the Georgia Apartment Association.
Good evening, Mr. Chairman, members of the committee. My name is Hayden Stanley on behalf of the Georgia Apartment Association. I'd like to begin by thanking Senator Jackson and the chairperson for the work they put in. We did have a number of questions and requests, and they have largely been addressed. We find comfort in the fact that it tracks precisely with the domestic violence lease provision that we supported in 2018. We're comfortable with this concept. The tighter that you can make this, certainly the more comfort we have. However, the fact that there's a judicial order involved, or in the case of ex parte, a police report, which is tracking again existing law on domestic violence victims, it is the way to go at a minimum. So we just want to thank you and say that we are not opposed to this.
Thank you, Mr. Stanley. I appreciate your association's work with us on making the bill better, so I appreciate it coming to the table.
Thank you.
Any questions, Mr. Stanley? All right. We do have one question. Oh, you're getting eager. See, this is your first real judiciary hearing, Kay. So it always will be from now on. We're not quite ready yet. No questions for you.
Oh, okay.
You're good. Anybody else want to be heard on Senate Bill 75? At this time, I'll recognize Senator Kirkpatrick if you'd like to make a motion.
Thank you, Mr. Chairman. I'd like to move do pass on LC 412958S.
Do we have a second? So we have a motion by Senator Kirkpatrick, a second by Senator Parent. Any discussion? All those in favor of the bill, please raise your hand. Any opposed? It passes unanimously. Congratulations, Senator Jackson.
We'll see you on the Senate floor.
Yeah. We're too tired for hazing now tonight, so. All right, next we have Senate Bill 105, which is my bill. And I am working off 412961S. Does everybody have that bill in your folder? There are several people that wanted to be heard on this bill. I will briefly go through what the bill actually does, walk through the bill itself, and then let some of the folks that have been working on this issue for some time give a little bit more background for you. I will ask that the witnesses try to keep your testimony to a couple minutes if possible so we don't lose a quorum tonight. We have one bill still left as well. Senate Bill 105, what we're in essence trying to do is go back and perfect some reforms that this body supported several years back dealing with probation in our state. And we are going through and going back and trying to expedite and make it a clearer process for those that are eligible to have probation terminated in our state, but have not been able to get through that process. And in particular, when you get into the bill, you'll see the existing law on page 2 under section 1B, where somebody that has no prior felony conviction and has a sentence that does not have more than 12 months of incarceration is entitled by law to have a good behavior, a behavioral incentive date put into their sentence to where they'll be eligible to have their probation terminated 3 years, not to exceed 3 years from the day of the sentence. And you see under the current process we have, we didn't, of course, change that part of the law. But what we did do, when you get into starting on line 37, you'll see we're trying to make this process clear. Instead of having the current requirement that the person generally be compliant with the general and special conditions of probation and paid all restitution, we're now being clear and saying that if they have not had their probation revoked in the past 2 years, they paid all their restitution, they haven't had any other arrests for anything other than non-serious traffic violation, that they are eligible to have their probation terminated after that 3-year period. And you get into the next page, to making it clear that when someone is eligible, the officer overseeing their case, the Department of Community Supervision, will actually submit to the court an order that allows for his termination. Well, we've added you'll see on line 47, starting on line 46, that the court shall have a hearing within 90 days if there is any, shall have a hearing within 90 days once that's been submitted to them. And what we're trying to do with that process is make sure somebody is eligible, actually will get in front of a judge, will have their hearing to get their probation terminated. The goal with this bill and with the underlying law we had is, in Georgia, when somebody has been sentenced for a crime, and again, we're talking about crimes where you're not incarcerated for more than 1 year, there's not a life sentence involved, there's not obviously a death penalty involved in the case. Someone has done everything they're supposed to do. They've paid their restitution, they haven't gotten any more trouble. Those are the kind of people that have shown with their first offense, that they can be productive members of society. Instead of having them on non-reporting probation, and if they get in any sort of trouble, they suddenly become back a part of the criminal justice system itself and get back into the system, we're allowing them a path to actually have their probation terminated and making sure that that path is expedited and it's a process they can actually comply with under Georgia law. Going into on page 5, we included some of the same language you'll see where hearing will automatically be set where you have someone that has made a motion, generally in any case, to have their probation terminated. When that motion is made, the court shall set a hearing on that petition to terminate the probation within 90 days. Again, making sure somebody actually gets their matter heard in front of a judge to make sure they can have their day in court and actually argue their case. And lastly, under Section 2, starting on page 7 of the bill, under Georgia law, current law, probation cases, anybody that has a probated sentence of 3 years or more is automatically reviewed every 3 years by the officer responsible for the case. And what we've done here is we're making sure we put that same standard, that versus saying they generally comply with the special and general conditions of probation, they haven't had anything revoked for the last 2 years, they'll qualify. And if early termination, as we added on line 173, 174, if early termination is recommended by the officer, the court shall order that. We put that on line 176, 177, unless there's an objection filed by the prosecutor. And then again, there shall be a hearing within 90 days. Again, trying to make sure that someone that is eligible, somebody in this situation that has been reviewed, that gets to a judge and actually gets ruled on. It's not something that sits in the process. And that is what the technical side of the bill actually does. And again, some of the advocates in the room will talk a little bit more about how we got to this. I do want to say before I turn it over to them, this bill for me came from a working group of bipartisan senators that came together in the off season, as we call it, and looked at some more reforms we could do in our state, and look back on some of the criminal justice reform we've already done, especially under Governor Deal, a lot of things we already accomplished the 8 years that he was in office, and tried to find more ways we could address the system that we have. And one of the things that stood out that was brought to my attention, members of this working group, was a number of Georgians that sit on probation, and how per capita we have more people in this state on probation than any other state in the nation. And some of that is a side effect of criminal justice reform. It's great that less people are in jail, but as we've seen, when somebody is still sitting on probation, it is a situation that's right for them to suddenly, because of one mistake they may make, to get stuck in the criminal justice system with revocations. And then we know what happens from there. It prevents them from becoming productive members of society and actually moving past a mistake they made previously in their life. And one of the great things about this working group, as far as some of the groups involved, I think you'll hear from some of them now, you had the Georgia Justice Project working directly with them on this on one side, and the Faith and Freedom Coalition on the other side coming together. And you could say two groups that you don't always think about working on the issues together. Two groups that historically have been associated with different political parties, different sides of the political realm. They came together and said, these are things we all care about. This is something that cuts across Republican, Democrat. This is real reform in our state, and it's just an honor to get to work on this bill. And with that, I'll stop talking about the bill itself, unless anybody has any questions for me. I'd like y'all to hear from some of the people in the room. So I'll start with Lisa from the Georgia Justice Project. If you want to come up.
My mask off. Hello, thank you all so much. I know it's been a really long day, so I'm going to try and be clear and quick. Thank you. My name is Lisa McGann, and I am the Policy Director for the Georgia Justice Project, and I'm here with Rachel Holmes, who is the managing attorney at GJP. And as a way of background, we've been in the community for the past 35 years, and our mission really is to reduce all barriers to individuals in the criminal justice system, and especially coming out of incarceration. And we know that for people to be successful, they have to have access to economic opportunity. They have to have access to employment. And we also know that when you're serving a very long probation sentence, those two things are mutually exclusive. So we want to talk about the probation reforms of 2017, about the early termination pathways that are already in the law, and a way to make the probation reform of 2017 work better. So first, just a little bit of history. I know Senator Strickland already mentioned this, but right now Georgia has more individuals serving under community supervision, that's probation and parole, than any other state in the country, not just per capita, but on an absolute basis. I think we're tied with Texas, 3 times the national average. And you might wonder why. Do Georgians commit more crimes? No, they don't. We don't even rank in the top 20 of states in that regard. But the problem is we have very, very long probation sentences. And unlike many states, there's no cap on the number of years judges can sentence an individual to probation. It's really not uncommon in Georgia to have a sentence for decades. And we have clients and know individuals that are serving 25, 30, 40-year probation sentences. 36 states cap probation between 2 and 5 years. Many of our sister states, Alabama, Florida, Louisiana, South Carolina, North Carolina, West Virginia, they all cap probation. And that's because long probation sentences do not increase public safety. All national data and the testimony of our own Commissioner of Community Supervision will tell you that probation has diminishing returns after 18 to 24 months. And over-supervision has a punitive effect. It actually increases versus decreases the risk of criminal activity. And capping probation is exactly what the Criminal Justice Reform Council recommended in 2016. And instead, legislators took a different approach to reform, and they created these behavioral incentive dates, these BIDs. And in theory, BIDs created a new pathway for certain individuals to earn early termination through good behavior after serving 3 years. BIDs were in addition to the already existing early termination process that also allowed individuals to earn early termination through good behavior after 3 years. But the BID process wasn't consistent with the other early termination processes. So each pathway had its own eligibility criteria, their own definition of good behavior, court process, and court standard. So fast forward 3 years later, 2020, we have not seen the probation reform of 2017 work. There were 210,000 individuals serving under felony probation in 2017, and there's still 203,000 individuals serving felony probation in 2020. So it really did not have any impact. In addition, the Department of Community Supervision recently released their report card on the probation reforms of 2017. I think if I say that 5 times really fast, it'll, of the 50,000 cases that were eligible for BID, only 213 individuals actually received them. So there's surely more than one reason that the reforms of 2017 did not have the impact they were intended to. But a main reason is that it is unusual to have more than one mechanism for early termination. It's confusing, and the mechanics of each pathway were different, and some were not even complete. So the solution is, in our opinion, and we're very supportive of SB 105, because it standardizes the early termination pathways. So there's uniform eligibility criteria, there's uniform court process, and there's a uniform court standard. It's the same across the board. If you've served 3 years of probation, and that's already the law, you have not committed a new offense, you have not had a technical revocation in the last 24 months, and you've paid all restitution, you are eligible for early termination. And after all those hurdles, you then still have to be granted it by the judge. But at least the bill clarifies and consolidates that pathway. So let me summarize by saying this bill does not create wholesale new probation reform, but I think it will ensure that the probation reforms of 2017 work. And we strongly support it because of the clear criteria it sets that defines good behavior. It creates a uniform court process and court standard. It eliminates the existing confusion between the pathways. It will help tens of thousands of individuals who have proven their rehabilitation by exemplifying good behavior, and they've been law-abiding citizens. It'll save taxpayer dollars, and it will address this egregious number of individuals we have serving a long probation sentence, which is what I think legislators actually wanted to do in 2017. So.
All right. Senator Watson has a question.
I will tell you, The issue I have with probation is the recidivism rate. I presume that people with the bad behavior, egregious crimes, have a higher recidivism rate. I don't assume that, I know that. But this sounds like you've carved out someone who has paid restitution, paid their time, and seem like they're proactively working on turning over a new leaf. Do you have any numbers, statistics? I'd like to hear the bad, and then I'd like to hear what I presume is going to be good numbers.
Yeah, so you're exactly right, and most people who do reoffend in the first year. That's the predominant, but the reconviction rate in year one is 5.6%, and that's halved by year two, 3.4%.
Which group are we talking about now?
Georgians serving felony, all Georgians serving felony probation.
So, all right, so help me understand it. I mean, to me, so what was the number again? So
in year one, the reconviction rate was 5.6%.
For someone who's released from prison who's on probation, is 5.1%.
Will reoffend, yes.
5%. Wow. And so this group, do we have numbers on this group?
So I don't have it broken down by felony offense, whether it's a drug offense or a violent offense. But if you look at the Department of
I've seen the Department of Corrections numbers, and we're talking about the serious felonies. The conviction, the recidivism rate on that is, wow. I mean, I think it used to be 75%. Now it's down to, I think, 50%. That's the serious felonies. I don't know what the committee calls it, the 7 deadly sins or whatever. But so I'm a little bit. That's what I recall off the top of my head. That's what I was expecting to hear.
So I've never seen that number.
So
I've never
that's way
seen
too
that.
high.
Yeah.
Maybe.
I actually just looked at the Department of the Department of Corrections numbers for 2020. They list all admissions for 2020, and the number of new offenses, there were 6,000 individuals in total. Now, how many of those were on probation? They don't break that out in terms of reoffense. But if you look at all the work that was done during the Criminal Justice Reform Council years, they were able to do that, and it was less than half. So let's just say half of those were people serving probation. That's 3,000 people out of 200,000, so it's not a lot.
Okay. Any other questions? All right, thank you, Lisa.
Okay.
Next, we have Denny Chow, a student that wanted to speak on the bill. Is this the person that's going to call in?
Yeah,
okay.
we're gonna put him on the microphone.
Okay. We have 3 other folks that want to be heard on the bill, so we can try to keep into 2 minutes if possible.
Hi, Daniel. Rachel. I'm going to put you on speakerphone, and then you'll be able to testify, okay? So they're ready for you, okay? Say something, Denny.
Yeah, Liba 6:30.
Denny?
Yes.
Can you guys hear him?
Bring it up a little bit to the mic.
Okay. Denny, I think they're ready for you.
Okay, can everybody hear me good?
Yes.
Okay. First, thank you for having me. My name is Denny Chow. I'm here to testify and my support on Bill 105 concerning probation. I'm just going to quick and simple my story and why I believe I was chosen to speak. When I was 20 years old, I committed a crime. When I was 21, I was arrested for this crime. When I was 23, I was sentenced to prison. When I was 28, I was released from prison. I am 33 years old today. And since I've been out, I started a nonprofit called Change Matters. Our mission is to promote recidivism awareness, also talk about inequalities and disparities among people getting out of prison. I've also been featured in videos like Release that was Governor Dill was a part of. Also make my own videos using platforms like YouTube. I've also and still speak at universities, Mercer, Georgia State, Emory, just to name a couple. In a couple of months, I'll be getting my bachelor degree in accounting at my university. I'm currently an accountant at a manufacturing company here in Georgia. I handle some of their financial reports, financial statements, and because we're an international company, I do a lot of financial data translation. I have 2 boys. One is 16, the other one is 1.5. And in a couple months, I'll be closing on my first house that I am going to be purchasing with a conventional loan with a 20% down payment. So why am I here? It's because with all those accomplishments, I still am restricted and I still struggle. See, since I've been out, I've noticed that a lot of people like to judge, but a lot of people judge me based off what they can see. But the moments that make me who I am is the moments that most people can't see. See, you see that I'm about to purchase a house, but the reason I'm purchasing a house is because every renter that I go to denies me of rent because I'm on probation. So in the last couple of years, I moved in with my girlfriend's mom, and I've been saving up to purchase this house. So those things you guys don't see. And you guys see that I'm an accountant at a manufacturing company, but you don't see how many jobs during the interview denied me because me still being on probation and something that I did 13 years ago. And so my story is exceptional because I have accomplished a lot since I've been out. But yet, till this day, I'm still restricted on a lot of things that I can't do. It seems that every time I'm trying to reach for the moon, probation keeps pulling me back and restricts me to the bottom of the steps. And so I support this bill, speaking through Georgia Justice Project and their support of trying to help me end my probation, early termination, and what it stands for. And also understand what it feels like to experience going through probation and all the restrictions and all the inequalities that come with it.
Thank you, Denny.
Thank you, Mr. Chow. I appreciate being brave enough to share your story with us, and it shows how bills on paper like this can affect real lives, so I appreciate you doing that. Anybody have any questions for Mr. Chow? All right. Thank you. Thank you, Rachel. We have Scott Maurer and Mick Powell with DCS. I don't know if y'all both want to come up together. Yeah, if we can try to keep our testimony as brief as possible. We're going to lose a quorum in just a little bit, so somebody in the back wants to hear their bill heard, I think. Thank you.
I appreciate the opportunity to come speak to you today. You know, typically, Department of Community Supervision as a state agency is particularly part of the executive branch, doesn't advocate for any particular legislation unless it's agency legislations. And so we take the stance that we advise on impact. And so I just wanted to briefly talk to you today about impact. I did want to address one question that you had, sir, earlier about the recidivism rate. So Georgia tracks a 3-year reconviction rate. And that applies to anybody that re-enters the prison system after being released from the prison system within 3 years. The Department of Corrections usually tracks that data. I have not seen that they've had any recent 2020 or 2019 data, but the last that I saw, it usually tracks around 28%. 28%. So generally around 28% of people that are released from prison return to prison within 3 years of their release. Now that's not just probationers and parolees, that's anybody released from a prison facility. So I just wanted to address that real quick while I had the opportunity. Department of Community Supervision, of course, when the previous probation legislation in Senate Bill 174 went into effect, one of the things that we did as an agency was automated the majority of the conditions that made somebody eligible for early termination. And so when I say automation, I mean when that case is in our system, it automatically combs through what are the conditions for them to meet for early termination and automatically notify the officer supervising the case when they meet those conditions. And they're required to address that notification as soon as they get it. And if they don't, then it gets passed on to a manager and so forth. So we have a very good system in place to be able to automate any changes to the conditions of early termination or a bid date, for example. So I say that to say the impact that this bill would have on our agency is very minimal. We can very easily change those conditions within the system so that the automation notifications come to our officers when they meet whatever the criteria is. So if the criteria is changed to 2 years previously without any revocations, we can easily change that. Those officers would get those notifications so that cases don't get missed along the way. One of the issues with the bid date was the number of cases that, as of July 2017, that should have been eligible for a bid date that did not receive a bid date. This being a retroactive bill would address that. We believe that there are quite a few cases that would now have a bid date and be bid eligible, and so then therefore eligible for early termination. And as Lisa mentioned earlier, it still does not negate the process of that petition having to be given to the court and the judge making the ultimate decision on whether or not that case should be terminated. So in the interest of time, I'm certainly here to answer any questions if there are any questions of myself. But I did want to say that we're supportive of the legislation. We think it'll have a positive impact on the extremely large caseloads that our officers has, as well as the length of sentences on probation in Georgia. So I'm happy to answer any questions that anybody has at this time.
There's one question. You mentioned one issue being the original sentence by the judge doesn't always have that behavioral incentive date in there. If that's not in the sentence, does that mean that may not get into your automated system, where somebody that would have normally been eligible may not pop up for the officer to see that?
So the system is also going to identify people that meet the criteria for early termination. Those cases that are bid eligible are also eligible for early termination. So the majority of those cases should have been brought to that officer's attention to say, this person has been on supervision for 3 years. They haven't had any violations of any special or general conditions and the rest of the criteria. So those cases still should have came through to the officers to say this person's eligible for early termination, because the criteria, as Lisa alluded to earlier, the process is different, but the criteria is very similar.
Okay. Any questions for the department? All right. Thank you so much. Appreciate your testimony. We have two more. We have Sam Owens here.
Good evening, Chairman Strickland, members of the committee. Last time I was here was about 10 o'clock at night one evening when y'all were getting ready to get us through a hate crimes bill. So I want to thank you once again for passage last session. I'm here today on behalf of Reform Alliance. Simone Price is here with me. We've been very active in this process. The last gentleman said it really well, and that is simply that the bid process is not currently working. Due process is not being had for those individuals, and the changes that are proposed by the chairman would have a huge effect and would be much appreciated, both from an economic view for our state as well as a development perspective for those individuals that should no longer be on probation. Thank you.
Any questions, Mr. Owens? And thank you to the Reform Alliance for your help all the way with this bill as well. I didn't mention you earlier. Appreciate the work y'all are doing. Last but not least, Adam Pipkin with the Faith and Freedom Coalition.
Chairman Strickland, members of the committee, my name is Adam Pipkin. I'm the Executive Director for Faith and Freedom Coalition of Georgia, and we get involved in a variety of policy issues, but criminal justice is one that we've kind of jumped on the last couple of years, and Denny's story is exactly why we're involved in this. A guy that served his time, got out, has done his probation, seems to be trying to make a life for himself, on the right track, but probation kind of keeps holding him back. And you heard the statistics from Lisa, and we could go into even more, but Georgia's kind of behind the 8 ball on that for a lot of different reasons. So we just want to ask your favorable consideration for this bill, and appreciate your time and appreciate Chairman Strickland's work on this issue.
Any questions for Mr. Pipkin? All right, thank you. Nobody else has signed up to speak on this bill. Anybody else want to be heard on this bill? At this time, we will entertain a motion. Senator Watts. Motion to pass by Senator Parent. Is there a second by Senator Kennedy? Any discussion? All those in favor of the motion, please raise your hand. Any opposed? Passed unanimously. All right, thank you. Last bill on the agenda is Senate Bill 114. I think it's fitting that the person presenting this bill and me, the two of us chaired committees at 7 a.m. today, so whatever I've got left, hope you got a little more left in you than I got left in me, Randy. We are working off LC 364607.
Yes, sir. Thank you, Mr. Chairman. And like you, my tank's about empty. But you're a lot younger than I am. What LC 364607 hopes to accomplish is the vast majority of any legislation that I work on during the session directly comes from District 29, where I'm at. Issues that are brought to me by my constituents that in many cases I'm not aware of. And this is exactly where this one came from. I was contacted by an individual who owns an HVAC company in Columbus and has owned this HVAC company for about 30 years. His son has worked for him most of that time since his son was an adult. Several years ago, his son was arrested for a burglary tied to his addiction to meth. It was a nonviolent burglary, daytime burglary, nobody home. Went in, took a few items. Because of the good work by the Columbus Police Department, fingerprints were obtained and the individual was located and went to court in Superior Court, Muskogee County, the Chattahoochee Circuit, and was sentenced to 5 years with the Georgia Department of Corrections. The individual went into prison because he pled nolo contendere, and it was his first offense. He was sent to a prison down near Brunswick, where probably after about 90 days incarcerated there, he became the assistant maintenance man and was responsible for all HVAC issues dealing with that piece of state property. Upon his release, he still had about 2 years left on probation, and at that time his father had started getting ill and was looking at transferring the ownership of the business over to his son. His son had all of the certifications but had not passed the testing and licensing portion in order to own and operate an HVAC company here in Georgia. So when he contacted the licensing folks there in Macon and started speaking with the test proctor about signing up and taking the test, once they found out that he was a convicted felon and currently under supervision, they advised him that he would be unable to take the test under Georgia law. His father reached out to me. I knew the son, so I reached out to the licensing folks and found the law that was interfering with his progress because it was a nonviolent felony, and because he was still under limited supervision and was being ready to be released, he was being hamstrung. And so if you'll go to line 29, what we've added in here will allow individuals who are released from the prison system being under supervision by a community supervision officer, as such term is defined in Code Section 42-3-1, for the conviction of any felony or any crime involving moral turpitude, whether it occurred in the courts of this state or any other state, territory, or country, or in the courts of the United States, so long as such individual was not convicted of a felony violation of Chapter 5, Title 16, and I fully understand that this committee understands what those crimes are, nor convicted of a crime requiring registration on the state sexual offender registry. I certainly don't have to tell this committee what my focus is when it comes to criminal justice. My focus is always primarily going to be the victim of the crime. It's going to be the Georgian that was either beaten, robbed, sexually assaulted, or whatever. That's where my heart lies. But it's obvious that there are good people, and I've 95% of the individuals that I've ever arrested were good people that made bad choices. And so the change in this legislation, I think, will not only give these individuals opportunities to get their professional licenses in areas, unless that particular area of licensing was the reason that they were arrested and convicted of a felony to start with, such as if it were a, heaven forbid, an attorney that went into a trust fund or something that he or she was responsible for and were arrested and charged, then when they got out, their opportunity would probably be in another professional licensing area as opposed to that within the bar. So, but having individuals get out with certain skill sets and some of these skill sets are even obtained while they're in prison, such as HVAC training and other tech school training, having them get out and being told that they can't move forward in their profession, but they're relegated to a $9.15 hour a job that they're overqualified for, I think not only opens up an opportunity for that individual to reoffend, but I also think that it robs the economy of our state of the talent that individual is and gets back into the system. So I'm more than happy to answer any questions, and I certainly hope the committee would look favorably upon this legislation.
Senator Hatchett.
Just to clarify, right now we're, pouring in our money to train these felons in prison, and then when they get out, we're denying them access to the license that we poured our resources in to train.
Absolutely.
I like this bill.
Absolutely.
Any other questions for the author?
I'd like to make a motion.
You're about to get to do that. Anybody else want to be heard on the bill? Now is the time for a motion.
I move do pass.
Move to pass by Senator Hatchett. Do we have a second? Second by Senator Kirkpatrick. Any discussion on the bill? All those in favor, please raise your hand. Passed unanimously.
Thank you. Did anybody get a photo of Senator Jones with his hand raised up on one of my bills?
There's always a chance for a revote, so I don't even know. With that, we are adjourned. Thank you all for staying late. We have 3 hearings left. Monday, we have a hard 1 hour stop time because it's earlier hearing, and then next Wednesday, we'll probably have something similar to this again. Then following Monday is our last hearing with, once again, a hard 1 hour stop. So thank you so much for your patience.